Ms. Wilson.
Good afternoon. The Supreme Court of the United States has recognized that everyone, even a convicted murderer, every single convicted murderer, regardless of that person's crimes, how many victims, or the manner in which that person killed, is entitled to the fundamental respect for humanity. And the Supreme Court has recognized that there is an infinite possibility of compassionate or mitigating factors stemming from the diverse frailties of humankind. And the Supreme Court has said that the juror's consideration of that individualized information, that story that is unique to each defendant and each convicted murderer, should be made known to the sentencing jury because of the possibility of compassionate or mitigating factors stemming from the diverse frailties of humankind. And as I said to you yesterday, that's exactly why we are here in Phase 2. That's why we have a Phase 2. It's the fundamental respect for humanity that's mandated by the highest court in this land. That court recognizes that jurors sitting in judgment of a man's life should know about the man. In Phase 2, you are asked to consider aggravating circumstances. In order for you to consider that death is even a possible penalty, you must first find that the state has proved to you at least one aggravating factor beyond a reasonable doubt. You need to make sure you understand that the state's burden of proof on each single aggravating factor that they are seeking to prove is beyond a reasonable doubt. And the state is asking you to find that 3 aggravators apply here: the prior violent felony, pecuniary gain, and cold calculated and premeditated. So let's talk first about the prior violent felony. When you hear that, you may think that it requires the defendant to have a long, violent history. That's what it sounds like when it says prior violent felony. Mr. Hartung does not have that at all. The state would certainly have presented that information to you if it existed. But the reason they can argue that prior violent felony applies as an aggravator is because there's more than one victim in this case. So the law says that you are allowed, for that simple reason, to find that Mr. Hartung is guilty of a prior violent felony. So before this aberrant episode, there were no violent felonies in Mr. Hartung's life. It seems a little less than fair that the law allows that aggravating circumstance to be argued under these circumstances when somebody does not have that prior violent felony record. Nevertheless, that's what the law allows. And then pecuniary gain, or financial gain. We don't know for certain what facts you found in Phase 1. We don't know whether you believed Mr. Hartung killed his family to get their estate. I would just ask that as you are deliberating and considering this particular aggravating factor, ask yourselves if it was proven to you beyond a reasonable doubt as an aggravating factor. And then the third aggravating factor the state is asking you to find is that these crimes were cold, calculated, and premeditated. You have found Mr. Hartung guilty of 3 counts of first-degree murder, and that does include a requirement of premeditation. But the premeditation that you found in Phase 1 is not the same as the premeditation that's required for you to find in Phase 2. The judge will tell you that in order for this aggravating factor to apply in Phase 2, a heightened level of premeditation demonstrated by a substantial period of reflection is required. So it's a heightened level over the level that was required for you to find in Phase 1. So again, the state has the burden to prove an aggravating factor beyond a reasonable doubt. If an aggravating factor is found unanimously and no mitigation is found at all, a juror may still vote for a sentence of life imprisonment. There is never, ever a requirement for you to vote for death. You can always bestow mercy, and you can vote for life. Because the decision as to whether to sentence a person to death is such a monumental decision, the law treats aggravating factors and mitigating factors very differently in several respects. The judge will tell you that no facts other than proven aggravating factors may be considered in support of a death sentence. Unlike mitigation, aggravation can't come from just anywhere. It's limited to those 3 things that the state has asked you for. If you find other things offensive about the crimes, you cannot use those as aggravating factors upon which to base a sentence of death. As upsetting as it is that Mr. Hartung has been found guilty of killing his family members, his mother and his 2 half-brothers, that is not an aggravating circumstance that you can use as a basis for imposing the death penalty. And you heard from 3 people yesterday who were understandably upset about the loss of the victims. You're allowed to hear that evidence because those people were parts of the community. The victims were a part of the community, and their loss has hurt people. So you are allowed to hear that. You are not allowed to take that as an aggravating factor. So now let's talk about mitigating circumstances, and specifically about Mr. Hartung and some of his life experiences. At this point, you probably understand what mitigation is. It's the character and the background of Mr. Hartung. It's anything that, in fairness and mercy, reduces his moral culpability for the crime. And anything that you individually, each one of you, considers, it's a basis for a life sentence. Mitigating circumstances can be found anywhere. Anything whatsoever that may indicate to you that the death penalty is not appropriate. The mitigating circumstance does not have to be related to the crime. It can include any aspect of the defendant's character, background, life, or circumstance of the offense that may indicate that the death penalty is not the appropriate penalty. A mitigating circumstance does not need to be established to the degree that an aggravating factor does. It only needs to be established by the greater weight of the evidence, more likely than not. The law requires each of you to give meaningful consideration and effect to each and every piece of mitigating evidence. It's your right and your obligation to decide for yourself how much weight to give each piece of mitigating evidence. based on your individualized moral judgment. And even if I don't tell you about a mitigating circumstance, if it's something that you have seen or heard or not heard, and you find it mitigating, then it's valid. When we first met, over 3 weeks ago now, I asked each and every one of you if you could consider evidence of childhood trauma as a mitigating circumstance, and every one of you said that you could. And you have heard about childhood trauma suffered by Mr. Hartung. You've heard about an innocent little boy who was sexually molested by a relative and then by a babysitter. So we have a picture of Mr. Hartung from a school yearbook in 1966, when he was 8 or 9 years old. So when this picture was taken, when he went home from school, he very well may have gone home to be sexually molested some more. He was molested by his uncle not once, but for years. He was molested by a babysitter. How many times does a child have to be sexually molested before it can be termed a traumatic childhood? Once should be more than enough. And in Mr. Hartung's case, with this little boy, we have tens of times, if not hundreds of times. Mr. Hartung, as a little boy, he wasn't just sexually victimized and exposed to trauma, he was incubated in trauma when he was growing up. You heard Dr. Zeman and Dr. Turner talk about adverse childhood experiences. And even the state's expert agreed that adverse childhood experiences and negative environments can shape a person's personality. Research on those experiences is shown to correlate to poorer outcomes in life, poorer medical outcomes, poorer mental health. Those people tend to die younger. They suffer from chronic diseases at a higher rate, and they suffer from depression. They often exhibit a lack of affect, insecure attachments, inability to maintain relationships. All of these things start from a very young age. And if you can remember back to something that you saw in phase 1, you heard several hours of interviews with Mr. Hartung by investigator Infinger, and the investigator kept saying, basically, why aren't you upset? You should be upset. This is why Mr. Hartung was not showing any upset. That is a direct symptom of an adverse childhood, and all those adverse childhood experiences, they quit showing anything. And Mr. Hartung had years' worth of those terrible childhood experiences, and he had no escape. There are certain factors that are listed under the statutes that you will hear about that, if they're proved to you by the greater weight of the evidence, you can find them as a mitigating factor, and you give it however much weight you think is appropriate. And one of those that Dr. Colino had the opinion applied was that the murders were committed while the defendant was under the influence of extreme mental or emotional disturbance. And Dr. Colino based that primarily on looking at the condition of Mr. Hartung's brain. And we'll talk more about that in a few minutes. Dr. Colino also opined that the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. And he did not have an opinion about Mr. Hartung's knowledge of right or wrong, but he did have an opinion that Mr. Hartung, because of this frontal lobe impairment, this severe atrophy, did not have the ability to conform his requirements, or his conduct, to the requirements of the law. And the state says, well, Dr. Colino changed the language a little bit, so therefore that one doesn't apply. Again, we are not limited to what it says in the statutes as to what is mitigating. So if the language is changed, that doesn't mean it's not a mitigating factor. If you find it mitigating, then it's mitigating. You'll also be told about the existence of any other factors in the defendant's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. So the judge is basically telling you in this jury instruction that it's what I've been telling you. Anything that you find mitigating is mitigating. It doesn't have to be listed somewhere. Whatever you find, it's valid. And I submit to you that there is a long list of mitigation that may not be listed in the statutes. They can't possibly come up with a comprehensive list that would apply to everyone in the statutes, because every defendant is an individual, like the Supreme Court recognizes. So in this case, there is extensive mitigation. One of the things that you heard from Dr. Zeman is a couple of things that Mr. Hartung is not. Donald Wayne Hartung is not a sociopath. He does not have an antisocial personality disorder. You also heard that on the testing, both in Dr. Zeman's opinion and in Dr. Turner's opinion, Mr. Hartung was giving it an honest effort on the testing. He was not trying to skew the results in any way. He was not malingering. Again, you heard about extreme sexual abuse by multiple perpetrators. You heard that Mr. Hartung never knew his father. He was abandoned by his father when he was 3 weeks old. He's been diagnosed with a mental health disorder, that being major depression. He's experienced extreme environmental trauma from the sexual abuse, you heard about his house burning down when he was 10 years old. He experienced a violent incident when his mother shot a peeping Tom, and then she experienced a nervous breakdown from that. And then you heard from Donald Hartung Jr. that Mr. Hartung was a good dad until he put it till he was roughly 11 or 12 years old when the alcohol kind of took over Mr. Hartung's life. And then things went south. But until then, Mr. Hartung, he participated in sports with his son. He coached the Little League baseball team. And let's not forget the incident where Mr. Hartung's younger brother, John, exposed himself to Donald Hartung Jr. And this Mr. Hartung, when he tried to bring up the incident with his mother said, "I don't want to hear it, John is different." And that was the end of that. And because his mother would not put a stop to it and would not protect Donald Hartung Jr., this man did. He protected his son from being further abused, which is what a good dad does. You heard that Mr. Hartung had a job as a security officer for a number of years without any kind of problems. And in fact, not only did he not have problems, he got some awards. He got July 2013, Security Officer of the Month. He did well. He also got the 2013 G4S Integrity Award. Not only could he hold down a job, he could perform well. You've been shown a copy of a membership card for the Creek Confederation of Florida for Mr. Donald Wayne Hartung. You've heard that Mr. Hartung has no significant criminal history prior to this incident. You've heard that he suffers from a detachment disorder. You've heard that he was not protected from all those incidents of sexual abuse. And then there's another mitigating circumstance. Talk about Mr. Hartung's brain. You've been shown pictures of Hartung's brain. Generally, unless we're trained way, we don't know what we're looking at these type of images, and that's what Dr. Ford. And what Dr. pointed out to was our new areas. These photographs. There should be brain, there's not. Pointed out to you that that shows white should be white. Be showing because they're there, and likewise in these areas. In these areas. We have the analysis that Dr. Colleen his nerve software. Significant or what's in. If you look on the side of that chart, where it says cortical matter on the hemisphere in the second percentile on the first percentile, and relates to is on a test where it was the highest possible, 2 on the left, 1 on the right side. And we have the same thing if you look down on the caudate. It was within the normal range in the 14th percent. The right side was in the first again. Again, he's out of 100. And then on you have on that many area deficit, just a little deficit. We have left, second percentile, first percentile, middle frontal, right percentile, and on and on and on and on. These aren't minor deficits. These are major impairment, Mr. Hartung. And this is an objective test. It wasn't through a person's interpretation, a software interpretation. So it didn't know anything about the situation based on what it was given the result. And the result that Mr. Hartung's brain is severely impaired. Diagnosis that you heard about is still have a hard time saying that. Or is the diagnosis of fatal in a matter of years. Something asked for. It's something that was by anything he did. It wasn't by drinking, not on falling down one time too many. It's just there. And it developed over a period of years. Colino said it was like 2015, the type of thing that doesn't develop in weeks or months to this degree of severity. This neurodegenerative disease can affect behavior in incredible ways. Dr. Colino said that sometimes the presentation is a person who's just basically rocking along, doing okay. Suddenly, something that's just completely aberrant to them. And the exam gave had driven his lobe and is penetrated, and for that Phineas did an upstanding and never did anything, and then after that he kind of did everything a little right because and it was the lobe. But it's common. It does happen that the first presentation of this type of degenerative brain disease, it often gets diagnosed when someone commits an aberrant or a violent. It's common for people with dementia to become combative, aggressive. No one for certain when this began. That you heard quoted often says it's 3 years of addition, and here they had the same routine security job for years out of the ordinary, and then his awards, and he started active, but you heard that he lived a bit of an isolation in his, it was played in, and the last time anyone visit him in his house, besides anyone, 2000, when Richard came over that their father had died, and that was the last time one came. He lived a very isolated life. So observable in his behavior, there was not really anybody around them. Could not see when it started. Can, because that's just impossible. A person goes for like this on a basis, so something is different than generally the way it works. So Dr. Colino had this was present in 2000, and you heard Dr. he whether it was present in 2015. You heard Dr. Turner not say it was not present in 2015. Zeman. Okay, so we know we have large amount of in the brain, which is evidenced by seeing areas on the image where there should be brain, not. You see white spots here that should not be there. So Dr. Zeman explained why that matters. And he says, first of all, that you can observe trouble with awkward gaits, loss of ability to distinguish smells, incontinence, unusual habits, personality changes. And he said, whatever the cause of frontal lobe damage, that can impair one's ability to impulse control. And this is concentrated primarily in the frontal lobe. The front is like a car. So if you're driving a car and the brake fails, you're going to crash. So if you have a broken frontal lobe, it's like a broken brake. Without that functioning brake, stressful stimuli may be catastrophic failure in a person's ability to regulate. And a person's bad acts that follow this failure, they result of impulse control, not a loss of moral and not a loss of right or wrong. You also heard from Zeman that testing that a psychologist gives, it's able to document or at least validate dysfunction or shortcomings of the brain. There's no testing that developed through brain dysfunction. Some of the test results are normal range, are with impaired range. But the other reason that the testing doesn't completely, I can't say it doesn't validate, but it doesn't necessarily reflect this amount of atrophy is that there are portions of the brain, as it shows in this chart, there are parts of the brain that still function adequately. So you've got normal functioning, impaired functioning. So some of the testing may be directed at where are that function normally. So you don't have the board impaired results. And said if you had that, make the bad test results at malingering. Testing is reflected when there is a range of results, not when the results are all one or the other. And a few minutes ago, the state was talking about Dr. Colino, the fact that he's never been hired by the state, that his opinion is based on speculation, Well, what Dr. Colino said, which was mischaracterized earlier, was that he said that with 90% certainty, he can say that Mr. Hartung suffers from severe frontotemporal dementia. That's not based on speculation, that's based on images, and it's based on data that is shown to you in that chart. And Dr. Colino, he did make the statement to the jury, to you. He said, you know more about this case than I do. And he was talking about the facts of the case. He was referring to the fact that you've been sitting here now for weeks hearing about the facts of the case. But what Dr. Colino did not say was you know more about Mr. Hartung's brain than I do. Dr. Colino is the brain expert, and he knows quite a lot at this point about Mr. Hartung's brain. And you heard earlier that when someone progresses to the point of having severe dementia, then they might need to be institutionalized. And not to confuse the two terms, there's dementia and there's the physical aspect that we have here of severe brain atrophy. So we have brain atrophy here. We do have dementia that is caused by the atrophy, but the severe atrophy does not yet mean he's at severe dementia. He is certainly impaired, and every expert you heard had the opinion that he is impaired, and no one could say that he was not impaired by this brain degeneration in 2015. One of the difficulties is in many brain conditions, like you've heard a lot about CTE with the professional football players, it can't be definitively diagnosed until autopsy. So the best they can do until autopsy is images like this. And they use these images to make their diagnosis, and that's what we have here. And we have images that certainly show an abnormal brain. The power of the state has come up against Mr. Hartung, and the power of the state has convicted him based on facts presented to you and on your verdict. Those things are within your purview. But some things are not within the state's purview. They are within yours. The finding of whether to impose life or death is within your power, not the state's. When the state presents cold, hard facts to you, as it did in the first part of the trial when you were deciding guilt or innocence, it's largely devoid of emotion and devoid of feeling. The facts and interpreters of those facts speak for themselves, rather unemotionally. But this phase of the trial works very differently. This is not about the power of the state. This is not about the cold, hard, unemotional facts. It's not about guilt or innocence. That's already been decided. This phase of the trial is about your own personal, individual decision about whether this man, Donald Wayne Hartung, should be put to death. You will be instructed that you are to weigh certain factors in making that decision. But there's no magic formula that just lets you plug in certain facts and then it spits out what the result should be as to whether the sentence should be life or death. That would be so much easier if a machine could just tell you what to do. But this is purely a personal decision. It's personal to each of you based on factors that resonate within you. At this point, you don't all have to sit there and agree about what's been proven to you. You have to look within yourself, within your own mind, within your own heart, and determine what's been proven to you and what's important to you. And no one, not the judge, not the state, not me, can tell you at this point what is important to you, what should be important to you, you, the individual, with only the life experience that you have had. So the decision about whether a life sentence or a death sentence should be imposed is yours, and yours alone. When you go back into that jury room, you will never be asked to make a more important decision. That decision about whether a man should receive a life sentence or a death sentence. As I told you yesterday, Phase 2 and the mitigating circumstances we present to you are not about excusing all these brain images. That's not about excusing anything. What we have presented to you is about explaining and giving you the opportunity to understand that your ultimate decision is, no matter what, this person, Mr. Hartung, is never going to be released back onto the street. So the question is, do we lock this person up in prison, or are we a society that wants to kill these people? The Romans supported leniency for those who suffered from madness, and they thought to be mad was considered, that was a punishment in its own. And I'm not standing here telling you that Mr. Hartung is mad. He's not mad in that sense, but he has, in fact, lost a good portion of his brain function. The state is asking you to discount the difficulties that he's had. They reminded you of the brutality of the murders. You heard all about that in Phase 1. The murders were brutal, but they're asking you, remember that. Forget this. The state says the enormity of those murders outweighs any mitigating circumstances. But the truth is, the state can't change these images. They can't make the atrophy disappear. That is a fact. And that is up to you to consider and to weigh. The state said you agreed that you could sentence a person to death if it seemed appropriate to you. And you also agreed that you could sentence a person to life if it seemed appropriate to you. From beginning to end, judicial proceedings conducted for the purpose of deciding whether a defendant shall be put to death must be conducted with dignity and respect. Surely, this must include deliberations. Please don't rush through the verdict and through the verdict form. There's a lot to think about, and there's a lot to consider, and there's a lot to deliberate on. And remember, the law is always satisfied with a life verdict. You are never required, under any circumstances, to vote for death. Each of you has the absolute right under the law to decide that a life penalty is the appropriate punishment in this case, regardless of the aggravating circumstances and any number of aggravating circumstances. We don't need the death penalty to harshly punish murderers. We don't need the death penalty to honor victims and their families. That's not the purpose. Our universal desire to eradicate crime and keep everyone safe does not depend on the existence of one kind of punishment. So your ultimate question is, does the mitigation outweigh the aggravation, or do I have a reason that feels morally right in my heart such that a life sentence is appropriate in this case? If you decide it does, or if you're unsure, that jury deliberation room is the time to say so. You give the word, it ends with a life sentence. The law tells you, at this point, each one of you decides for yourself what is important and how important that is. You may value it differently than another juror, and that's up to you. It's up to you to make a moral determination about what value you assign to this brain-damaged man's life. If you decide that mitigating circumstances outweigh aggravating circumstances, that this devastating and serious brain impairment coupled with changes caused by his traumatic childhood was serious enough, was enough to outweigh any aggravating circumstances you find, or if you think it's appropriate to bestow mercy on this man, you need to tell your foreperson, I've considered everything that I've heard and seen, but from my heart and my soul, mitigation outweighs aggravation. The foreperson may disagree with you, but she will respect your decision. And then she'll sign the verdict form. And then Donald Wayne Hartung Sr. will spend the rest of his life in a prison cell. And ladies and gentlemen, I humbly submit to you that life without the possibility of parole is the appropriate resolution here.